Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
You don't want to. Your Honor, actually at this time, the defense intends to rest.
And just like that, a major strategic decision lands in the courtroom. The defense has chosen to rest its case without calling any witnesses. That's the kind of move that instantly gets legal analysts paying attention. The big question, does the defense believe the prosecution failed to meet its burden, or are they avoiding risks that come with putting witnesses on the stand?
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
This exchange may sound routine, but it's incredibly important. A defendant has a constitutional right to testify, and the judge needs to confirm that any decision not to take the stand is made knowingly and voluntarily. Viewers, what would you do in this situation? Testify and tell your side directly, or stay silent and avoid cross-examination?
Okay. Ms. Richins, may I ask you two direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
Notice how the tone in the courtroom shifts here. The evidence phase is effectively over, and now the focus moves to jury instructions, the rules that tell jurors exactly how they must evaluate the case. It may not be the most dramatic part of a trial, but these instructions can have an enormous impact on how a verdict is reached.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
The judge's comment gets a laugh, but there's a serious point underneath it. Judges work hard to avoid signaling favoritism or revealing what they think about the evidence. Even a facial expression can become a talking point in a closely watched trial. That's how carefully courtroom neutrality is protected.
So let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin, the parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought we were thinking it might make sense to get the jury instruction conference out of the way, and then...
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah, yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning, yes?
Yes.
Yes, sir.
Okay. Okay. we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
This is a pivotal courtroom moment. The prosecution has rested. The defense has rested. No more witnesses. No more evidence. From here, the case begins transitioning toward the final arguments that will shape how jurors interpret everything they've heard so far. The finish line is suddenly much closer than it was just minutes ago. When the judge says the jury will be out in the wild, he's speaking with a bit of humor, but the responsibility is very real. Jurors are expected to avoid outside information, news coverage, and discussions about the case. As this break begins, the challenge becomes preserving an unbiased decision-making process until deliberations finally arrive.
All rise for the jury. Please have a seat as you come in. Have a seat, thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning.